We go. Well, welcome everybody to our Step Parent Adoption webinar. Today is June 10, 2021, and I'm thrilled to have Trish Haas with me today. Trish is an attorney in Grosse Pointe at the firm of Haas and Prokopec. Did I say that right?
You did.
Prokopec? Yay, okay. So Trish and I go way back, actually. We have not only been opposing counsel, we've been co-counsel. Trish and I did a family law appellate webinar for ICL a couple of years ago. I couldn't remember the date. It felt like a million years ago, but apparently it was just in 2019. Who would have thought? And she and I also sit together on a very informal group called the Michigan Coalition of Family Law Appellate Attorneys, where we are with a group of 6 appellate attorneys, and we often will submit amicus briefs in the Michigan Supreme Court on issues that family law appellate attorneys agree on. So we get to spend a lot of time together. I think we're on some other committees together as well. So welcome to Trish. We're so glad to have you today. And one of the reasons I asked Trish to come on for this topic, and she and I have worked on enough stuff together, I probably could have asked her any number of family law related topics, but she had a special interest in step-parent adoptions because she was one of the attorneys in the In Re AJR case. And we'll talk about that in a minute. And that led to a statutory change after the Supreme Court decided AJR. So I thought it was really fitting that we would have Trish here. And there's another case we'll be talking about today, which I think now requires another statutory fix that I happen to work on, called In Re AGD. So there's this kind of small universe of people who have worked on step-parent adoption appeals. So welcome, Trish.
Thank you.
I don't know if we should start off by talking just a little bit about the history for the people who have, because AJR was now in 2014. Again, it's hard to believe it's been that long. But to give a little bit of history about AJR and then what happened after AJR, just to kind of put the framework of the statute that we have today exist because there were some changes made after AJR. And when we get to the current version of the statute, I'm going to share a screen too, because the language in the statute is kind of confusing, and I think it might be easier for everybody if they can see what we're talking about. So you want to tell them a little bit about your work on AJR and what came from it?
Sure. Well, I would say that my work on AJR probably, although the result was favorable to my client, I think it was disappointing to a lot of practitioners. And the reason being is because the way the Michigan Supreme Court interpreted the statute in Re AJR, they interpreted it to mean that anytime a parent had shared legal custody with their spouse or ex-spouse, that meant that in order to proceed with a step-parent adoption, you must first terminate the other parent's status as a joint legal custodian before you could proceed to a step-parent adoption. And I think a lot of the adoption attorneys found this an unfavorable result. They looked at this as a bar to adoptions, to step-parent adoptions, because a lot of times, as we all know as practitioners, joint legal custody is the default in divorces. So because joint legal custody was a default in a lot of cases, that meant that it precluded the opportunity for step-parent adoption. So I think that is what then led to the statutory amendment in 2016 that changed the wording "the parent" to "a parent." And that was, of course, intended to make step-parent adoption more widely available, because that then was an indication that the parent just had to have custody. It didn't have to have sole legal custody as the statute in Re AJR had been interpreted. But unfortunately, as you know, Lisa, the amendment has led to more problems probably than ever anticipated. And I think you could speak to that.
Yeah, so before we dive into the problems with the current statute, I wanted to point out a couple things, that the decision of the Supreme Court in Re JR turned on the word "a" versus "the." So because the statute said a parent with legal custody, no, it said the parent with legal custody instead of a parent with legal custody, the Supreme Court interpreted it to mean that the parent with legal custody can only be the only parent, the sole legal custodian. And that's really, I think, highlights the importance of word choice in statutes and in contracts. Like, if you can have the meaning of a case on whether "a" or "the" is used, it's a pretty significant difference for the outcome of a case. And the other thing I wanted to point out with AJR. I already forgot what it was. So, so they did the statutory change, like Trish mentioned, and I'm going to pull up the statute just to help everybody because, like I said, the language is confusing. And one of the things it did was it did make it easier to do a step-parent adoption. Oh, I know. My point was this. In Trish's case, just like in cases now, when we're talking about a parent was the parent with sole legal custody or now a parent who has custody by order, that's like the way to get in the door, right? But that's putting aside that they may, the parent who wants to do the step-parent adoption, they may have tons of proof on the other two elements. And we'll talk about the other two elements as well, about the failure to provide substantial regular support, or the failure to substantially and regularly fail to visit or communicate with the child. So assuming all those things are completely proven, it doesn't matter if you can't get in the door because before you weren't the legal custody parent, and now it's because you're not a parent who has custody by court order. So let's pull up the statute really quickly. And I think you're just going to shrink. Nope, that's the wrong thing. What am I pulling up? It's a docketing statement. Oof. That was not what I wanted. Oh, here it is. Okay. All right. So now let's look at the language, and I apologize that we're a little bit smaller, but I think it will help for you to see the language. This is the provision that gets you in the door that Trish was talking about that they changed because of AJR. And it says if the parents or the child are divorced, or if the parents are unmarried, but the father is acknowledged, or if there's a putative father, then a parent having custody of the child. So we understand it that the intent was to make it open. So here's the next question, that the question we really wanted to talk about, because this is what came up in AGD, is what about, because it talks about parents who are divorced, or if there's an acknowledged father, or if there's a putative father. So let's talk about what it means to be a parent having custody of the child according to a court order. Trish, do you want to start by addressing that?
Sure. Obviously, anytime you have parents who are divorced, the judgment of divorce is going to include a custody award. So any divorced parent is obviously going to be eligible for a step-parent adoption with this language if they have any kind of custody, according to the way it's rewritten. But the problem is that, as we all know, an acknowledgement of paternity is not an order granting custody. So therefore, if the parents were not married, the way this reads and the way your case was interpreted, and I think you could speak more to that, is that there has to be an order granting custody. So, acknowledgement of paternity doesn't do that. When you have a putative father, you don't have an order granting custody. So unfortunately, it looks like the statutory amendment actually created more problems than the old statute.
Right. So a different set of problems, at least. And maybe it's a smaller universe. Maybe it's a smaller universe of problems, because what, Trish, you recognize is that a lot of judges in Michigan really do want to award joint legal custody, even if there's a parent who's not really involved. They're really inclinations to award joint legal custody. So maybe the universe of problems is actually a lot smaller now, because it only impacts negatively those parents who are one as a legal parent by acknowledgement, which, like you said, is not a court order. So then some moms, and I think a lot of times, and I could be wrong, but a lot of times the person who is the mom is trying to get her husband to be the adoptive parent and terminate the rights of the biological father. I mean, I know there's other cases that are not that scenario, but I think more often than not, the ones I've seen, it's the mother who wants her husband to adopt the children and then terminate the rights of the father. So, I mean, I'm not trying to be simplistic, but I probably will refer to the mother more just because it's easier to kind of keep it in our head. So let's talk about, what is a mom supposed to do now that we know from the In Re AGD case that the fact that she had an acknowledgement of paternity, and that the dad hadn't been visiting and the dad hadn't been paying support for like at least 3 years, or 4 years, 3 or 4 years by the time she filed her adoption petition, or the husband filed the adoption petition. she had to get a custody order first. So let's talk about like the pros and cons, or how that would work out for the mom in that one context of having an acknowledgement of paternity, to create the legal relationship between the child and the biological father. So Trish, do you have any, like, what would you recommend to that client who walks in your door and you learn that she doesn't have a custody order because it just never happened, and there wasn't like, she didn't want the support, she didn't need the support, she was trying to keep the guy, didn't really need him in his life, and maybe he hadn't shown any interest in being in the child's life, so like, let sleeping dogs lie, right? And then until she wants to do an adoption. So go ahead, what would you suggest to your client?
Well, unfortunately, the way the statute reads, I think it's undeniable that this particular mother would have to go to court and obtain a court order granting her custody. I don't see that there's any way around that. And of course, that's very disappointing, because a lot of times if you have a father that's absent or a mother that's absent, the fact that you have to file a case, serve that party, maybe they won't respond, maybe you can get a default order for custody, but assuming they respond, you very well might open up a can of worms where this father or mother now suddenly seeks interest, and therefore you're invalidating the second prong of the statute, which requires the failure to substantially support or visit. You might negate that by opening the door by having to file a custody case. And ironically, like I said, I think the statutory amendment was intended to avoid that problem, so that a parent who was trying to terminate rights didn't have to first go to court to get a sole legal custody order. But now you don't have to get a sole legal custody order, but you have to go to court to get an order, which very well may open up a can of worms.
Yeah, I think it puts that parent, the mother in my example, in the time period between AJR and when the adoption statute was changed, what I call the AJR fix, when the legislature decided to make some changes because of AJR, it was like a 2-year or 1.5-year window. During that window, after the Supreme Court decision, if you were a parent who had joint legal custody, your only option if you wanted to do a step parent adoption was to go do a motion and ask for sole legal custody. And of course, you have to then have proper cause, change of circumstances. Actually, I think it would be quite hard. And that would cause, I think, a bigger problem. But even as a mother with an acknowledgement of paternity, you probably don't have to show proper cause or change of circumstances because there's no custody order to begin with. So you don't have to meet the threshold. But you do have to go in front of a court, file a motion. There might have to be a hearing. And then there might have to, all the things that go along with getting any custody order. It may not be cut and dry. So it does cause some problems for a smaller universe of people. So let's change topics. And I do know we have some questions, and I'm going to bring them up in a little bit because I don't know that they're necessarily relevant quite yet, but they will be. The context of the putative father. So the statute explicitly says that you can have a step parent adoption. I'm going to put that back up. Have a step parent adoption when there's a putative father, right? Oops, what did I do? Okay, can you see it?
Yes.
Okay, good. It says if the parents are divorced or if the putative father meets the conditions in section 39.2 of this chapter. So section 39 sub 2 of the adoption code section 39 of the adoption code is how like in a direct placement adoption situation, the mother who is an unwed mother wants to usually have a child go home with another family and get adopted by another family, usually from the hospital. She can terminate the putative father's rights unless, and this is what 39.2 references, unless during the pregnancy or the 90 days before the adoption hearing was initially scheduled, the putative father provided substantial and regular support or had an established custodial relationship with the child. And if he did either of those things, then you cannot terminate him under section 39 of the adoption code. You can only do the adoption through the step parent adoption provision, which means there has to be 2 years of not substantially regularly supporting the child, not just during the pregnancy. So it's a longer window, right? So it's referring to the ability to terminate somebody who's a putative father. So Trish, can you tell us what you think might be a problem with the way the statute's worded if it envisions the ability to terminate a putative father?
Well, obviously, if you have a
Dot, dot,
putative
dot.
father, yeah, if you have a putative father, you certainly don't have an order granting custody. So in essence, you won't have a putative father if you want to proceed with step-parent adoption, because you're going to need to get a court order that grants you custody. And the only way you're going to do that is by naming somebody as the father and starting a court case, a paternity action. So you still, same problem. If you have a putative father, you still need a court order, which is
So
an unintended consequence of the statute.
So basically, the way the statute's written, I think, is nonsensical. I argued that in AJD, but the Court of Appeals did not agree with me. So whatever. They don't always agree with me, if you can believe it or not. A mom would have to make the dad a legal father before she can pursue a step-parent adoption. And that's just it. The statute doesn't say that, but that's the consequence of the court's interpretation and the legislative words that were used in AGD. So what if the father is deceased? Like the biological father is no longer alive. Do you know, like, I have some thoughts, but I wanted to see if you had any ideas of how that would apply then.
Gosh, Lisa, to be honest, I haven't given that much thought. So I would want to give that thought before I answered. So I'd like to defer to you on that.
Okay, I have an idea, and I did recently have a case where there was a deceased parent, and actually it was a mother had a new husband. I represented the new husband, and the biological legal father was deceased. And so she wanted to have her 3 children adopted by her husband. And I think, technically it's a step-parent adoption, but none of I'm going to share the screen again. If we're looking at subsection 6, 5 and 6, and then AB, they really don't have anything. They only have to do with when you have this other person, who's alive, who happens to be the legal father or a putative father. How do you terminate their rights? It doesn't address the instance where that person may not be alive anymore. So I'm going to scroll up to subsection 1 because I think that applies. At least in this context. I'm not sure if this is intended to apply to all step-parent adoptions, but it talks about, in every case, there's a report of investigation that's done by, I don't remember who does it. Is it DHHS or somebody does some sort of, or maybe there's a caseworker, an adoption caseworker at the court. If you know, Trish, let me know, but I'm not sure exactly who does the report of investigation, but it basically gives the judge information about, is this adoption a good idea or not? It's not the same as a home study from what I can gather. And if there are any adoption attorneys attending today, feel free to share your thoughts on the chat. I looked at the attendance list earlier today. I didn't see anybody that jumped out at me as doing adoption work under the rest of the adoption code. But it talks about having to make sure that the genuineness of the consent to the adopt and the authority of the person signing consent. So this could apply, for example, when the father says, yeah, I'll release my rights, right? Trish, you and I talked about that. This definitely could apply at that point when the father says, yeah, I'm not being a good dad. I want this other person, this man who's raising my child, to be the legal father. But I think it can also apply in the context where the father is deceased. And when we did get a case like that, we actually got a reversal because the judge denied the adoption without doing best interest. And so it got remanded to do the best interest analysis, which is obviously right here required under section 51(1) of the adoption code. So, my question, and I'm not necessarily expecting you to answer, Trish, but does this statute discriminate against unmarried mothers? Like unwed mothers who are always unwed, not the ones that are divorced.
I guess you could certainly make that argument because there is no avenue for unmarried mothers who just have an acknowledgement of paternity or who perhaps don't even know who the father is. It appears that there's really no way to secure a step-parent adoption under those circumstances, the way the statute's written. And I'm sure, like we discussed, this probably was an unintended consequence of the statute. I believe that.
Evelyn Calagero, I think, answered my question, which is thank you, Evelyn. She said that some counties have their own investigators do the investigations, and then other counties have the agency do it. So I think it depends on what's going on with that particular county. The case, I think in AGD, it was the county who did their own investigation, and that report was put into the adoption file. Thank you, Evelyn. I appreciate that. Before we move on to the other requirements of the step-parent adoption provision, I'm going to share another question that came up. And I'm going to let Trish try to answer it first. I have a thought of what the answer is. Can a child inherit from a biological parent in a probate proceeding if there was a prior step-parent adoption where the bio-parent agreed to the adoption, but then dies intestate? So I think the scenario is, let's just use the mom as a hypothetical. Mom has husband adopts. So now it's adoption has been done. And the bio parent consented. I don't know that it matters if there was a consent or it was involuntary, but then dies intestate. So he doesn't have a will, but would the biological father, would the child be able to inherit from the biological father? I think that's the question. And Elizabeth, if I'm wrong about what your question is, please let me know.
Well, you know what? I have to tell you, Lisa, that I really have only practiced family law exclusively. So I really don't know the answer to that question. I'm happy to say I don't know the answer.
Good. Well, actually, I do.
All right. I knew you would.
I feel like, woo.
Yes. I mean, if I don't know the answer, I'm going to tell you, I don't know.
But if you have thoughts, we're happy to hear them. One of the very first adoption appeals I did, and this was a long time ago. I didn't have, it had to be, I'm going to say 2005, because it was before I even had my own firm. The issue was, could somebody, when they've been adopted, could they inherit from the biological family? And the case ended up settling, but I did do the brief. But the reality is, once a step-parent adoption happens, any kind of adoption, doesn't matter if it's step-parent or not, that severs the ties with that biological parent and family forever. So the step parent who adopted the child, his family becomes the legal family of the child, and the biological father, who in this example died intestate, has no relation to that child. So if he wanted to leave something for his biological child who's no longer his legal child, he would have to do it in a will, because of course you can leave a will and give it to anybody you want. This issue has come up in the Michigan Supreme Court in the grandparenting time context. So you know how when you read the grandparenting time provision of the Child Custody Act, it makes it look like if there's an adoption, the idea has been like, well, once the parents' rights are terminated, does that end the rights of the grandparents to seek grandparenting time, because it cuts the relationship with that family when the parents' rights are terminated? And a Court of Appeals opinion said, yes, it cuts off the rights. But then later, the Michigan Supreme Court said in a different case, until there's an adoption, those grandparents can still seek grandparenting time, even though their child's rights have been terminated to the grandchild. And so I think the turning issue for the Supreme Court in that case called Porter versus Hill was the fact that an adoption had not happened. So I think that confirms my instinct in answering Elizabeth's question, that the adoption is what severs the relationship, not just to the parent, but to any of the parent's relatives. It's just like that whole part of the family is severed. And then the step parent's family is now like that adopted child could inherit from the stepfather's parents now, if something were to happen, that they could inherit through intestate succession. So I hope that answered the question. And somebody provided a statute, MCL 700.2114 sub 2, an adopted individual is a child of his or her adoptive parent. So this is EPIC, by the way, the Estate and Protected Individuals Code. Thank you, Catherine, for sharing. But if the adoption of a child by the spouse or either natural parent has no effect on either the relationship between the child and the natural parent, wait, hold on. But adoption of a child by a spouse of either the natural parent has no effect on either the relationship between the child and the natural parent or the right of the child or to the descendant of the child to inherit from or through the other natural parent. I think my answer was wrong. I'm going to have to, I think I'm going to read it again. This is confusing. So this is under EPIC. An individual is considered to be adopted for purposes of the subject when a court of competent jurisdiction. Okay, we're going to have to think about it. We're going to have takeaways after this. I'm going to have to ponder this provision for a while because this is not what I thought the law was, and that's okay.
And what's also interesting about
Can you
that,
see?
Lisa,
Can you see it, Trish? Do you see the
I
the chat? Okay.
Yeah. I thought at some point I remembered reading something like this, but so I do recall reading this at some point and finding it interesting. And also, I guess the other issue is just because a parent's rights to their child is terminated, that doesn't stop the court from ordering that terminated parents to continue to support the child. So I think since they can continue to provide child support, it only makes sense that they also should.
But that obligation ends once an adoption happens.
Okay.
So, I mean, I remember when that case came out, and that right now I can't remember what the name of the case is, and I bet Evelyn, Evelyn will know probably offhand. I remember when that case came out, but it said even though your rights have been terminated involuntarily, you still get to pay child support.
Yeah.
But once the adoption happens, that person has no legal obligation to a child that's been adopted by somebody else. So I'm curious about this EPIC provision, but it looks the way because it refers to the other natural parent. So it talks about a natural parent and the other natural parent. They can't just be talking about the mom in this context of a step-parent adoption statute. We'll figure it out. I'll make sure we share that case name in our takeaways. I used to know what it was, but it's just slipping my mind right now. Okay, let's switch topics. Let's talk about the 2 years of failing to substantially and regularly support the child. So in the step-parent adoption context, you have to meet two elements, the support element and the lack of visitation element. So, and it's required to show both. So let's first talk about the support, and I'm going to pull up again the statute, and we're going to go down to sub 6A. The other parent having the ability to support or assist in supporting the child has failed or neglected to provide regular and substantial support for a period of 2 years before the filing of the adoption petition. Now, there's more that we're going to talk about in a minute, but before we do that, let's talk. Trish, do you have any thoughts about some examples of what might fail to be substantial regular support, or what might be enough substantial regular support to shut down an adoption from happening?
Well, the case law really isn't clear on this issue. What I actually wound up arguing in AJR was the Black's letter law definition of substantially fail to comply, because most of the cases that are published of step-parent adoptions that were successful based upon a failure to support really had no payment of child support. So in my case in AJR, although the court never got to the merits of my case because I won on the statutory interpretation issue, my guy had paid 43% of his support, and I argued that was
43%.
Yes. So
okay.
I argued that was not a substantial failure to support because Black letter law defines that as, let me find it, looking on the other screen. It's being largely but not wholly that which is specified. So that's what I ultimately relied on.
Is less than 50% qualify as largely but not wholly? You argued it was. I would probably argue the opposite, but that's okay.
Of course.
I mean, I don't know what, but there's no bright line, right? I mean, in one case, 75% might be substantial, but maybe the regular part would pose a problem. What if you paid all your support for what if you paid all your support for 18 months, but the last 6 months you paid zero? I don't know. That would probably not be enough to do a termination. I'm just guessing. Yeah. I don't really know the answer to that, but or if you paid 75% of your support for the first in the 2 year window that we're looking at, because it's just a 2 year for the period of 2 years. So if for that 2-year period you paid half of your support, and then for 1 year you pay nothing, is that substantial and regular? I mean, it may be arguably substantial that I don't know, like I would say it's all very factually dependent, right?
Absolutely. Absolutely. Yeah, I mean, there, like you said, there are two prongs. It has regular and substantial support. So there has to be a failure to pay regular support, and there has to be a failure to substantially support. So it is a fact-intensive inquiry in all cases, no question.
Thank you, Evelyn, for sharing the site to INRAE Beck. And that's the one that Trish, the case you mentioned about the termination of parental rights does not end your obligation to provide support. And I think that was that's in the all panelists. So again, we'll include that in the takeaways, because it looked like it just might have just come to me and Trish. And then I was gonna just direct the audience to section 39 of the adoption code again, because it uses very similar language, the substantial and regular support language. So you might, if you're doing a step-parent adoption case, and I don't know how many cases did you find, published cases on this issue in the step-parent adoption context, Trish? I know you at one point had read every single case that had ever come out, but I don't know if there were were there a lot of published ones? I don't know that I get a sense that there was that many.
There really weren't a lot that addressed this issue.
There have been quite a few cases under section 39 of the adoption code, and that has some slightly different language, and we'll talk about that in a minute. But the part that's the same is the providing, what does it mean to provide substantial and regular support? And there's a lot of cases, I mean, they're talking about a different window. It's not a 2-year window. In those cases, it's like during the pregnancy or 90 days before the hearing. But there are cases that talk about, buying some diapers and filling up gas, or even paying for rent for a few months doesn't amount to substantial and regular support. And so, and there are other cases that maybe where the person was sending money more regularly, even if it wasn't from a support order. So you might find some cases that are helpful if you're trying to figure out the answer to that question. But I did want to point out again, let's go back to the statute. Something that is different than the section 39. Section 39 talks about in accordance with the person's ability to pay, and the step-parent adoption does not talk about in accordance with the person's ability to pay at all. So instead, it talks about having a zero support order and what the consequence of that is. So this is a really important change that came to the statute after AJR. So, I mean, I think when Trish and I were talking about this, we agreed that when they updated the statute after AJR, they probably should just have rewritten the whole section, because it's really confusing and there's a lot of holes. And you don't realize how many holes there are until you start working on one of these cases, and you're like, well, wait a minute, what about this and what about that? And it probably would have been helpful if they had just started from scratch. But putting that aside, they did do another fix that didn't have anything to do with AJR, right, Trish? So let's talk a little bit about what the statute said before regarding the zero support and how that's different now.
Okay. Well, prior to the 2016 amendment, there was no discussion about, quote, the statute as it reads now states, a child support order stating that support is zero or that support is reserved shall be treated in the same manner as if no support order had been entered. So previously, this provision was absent from the statute. And the result of that was that if there was a zero support order entered, or if support was reserved, a step-parent adoption was essentially impossible, because there was not a substantial and regular failure to comply with a support order because it was zero, or because it was reserved.
Because you 100% complied with the zero. You every month you paid your $0.
Exactly.
Religiously. Yeah.
Exactly. So this modification to the statute most certainly is a benefit, and it's certainly helpful to any parent who is trying to procure a step-parent adoption when they have a zero support order, because now it's possible to proceed with step-parent adoption, where previously the way the case law had been interpreting the statute, if you had a zero support order, there was pretty much no way to have a step-parent adoption, because there never was a substantial failure to comply.
So it looks like this is the second time now with the new statute that it appears to me that the legislature was trying to make it easier to proceed with the step-parent adoption. And we've already talked about what I think are unintended consequences of the language they used about having a court order above. But it looks like they were trying to make it easier to complete a step-parent adoption with all the problems that parents were facing in the past. I don't, do you agree with my thought process on that?
Absolutely. I do remember reading the legislative history to this amendment, and most certainly the intention was to make it easier. There's no question. And this provision does make it easier. There's no question.
So here's my question for you, Trish. For those parents before the amendment, before 2016, if there was a zero support order, what would their options have been? They have to go ask the judge, hey, award me $1 a month and let's see if he pays. I mean, it's just such a weird thing. Like, who's going to go ask for $5 or I don't know, just what do you think the options were for those parents in that situation?
I think you're right, Lisa. I think unfortunately, prior to this amendment, if somebody wanted to proceed with step-parent adoption, they would have to, and they had a zero support order, they would have to file a motion requesting child support so that there was a support order so there was a support order and then therefore failure to comply.
So
I don't think there's any option.
Let me ask you this question. What do you think, why would a judge, and of course it can still happen now, but now it's been addressed by the statute, but why would a judge enter a zero support order? What's the context that would happen in? That one parent is basically primary custodian, but they get no support. Why?
Well, probably I would say if the other parent was incarcerated, perhaps there would be a zero support order. I really think that's the only time I've ever seen a zero support order is when the other parent is incarcerated.
Okay. And that brings us to another statutory scheme that it's just important to understand how the step-parent adoption provision differs and is similar to we've talked about other provisions of the adoption code today. We've talked about EPIC, obviously, and I wanted to turn our attentions for a minute to the juvenile code because it has a recent case, or somewhat recent case, talks about this amendment to the step-parent adoption provision. And because of the amendment in the step-parent adoption provision, which did not happen in the juvenile code, it precluded an adoption from happening in the juvenile code when there was a zero support order. And that was called the case of Daily Minors. And that was where a grandmother wanted to adopt her grandchild because the dad was in prison and the dad had shot the mom. So she was like catastrophically injured. She couldn't take care of the child herself. So she was living with her mother and the mother was basically raising her child. And the guy's in prison. He's not supporting the child. He hasn't had any contact with the child. And she wants to do an adoption. And the Court of Appeals said that the judge did not have jurisdiction over him because unlike the step-parent provision, which has this safety valve now, a zero support order is just like as if no support had been entered. So you still have an obligation. You have a moral obligation to support your child. So even if there's no support awarded or ordered, you still have an obligation to support your child. But the juvenile code was not changed because why would they think about the juvenile code when they're changing there's so many pieces of the puzzle of things that fit together. But when the legislature is making changes, they're not necessarily going to understand how different things might respond to each other. So in that Daily case, and I will share the docket number, actually I'll share it with you right now. It's docket number 348064, but we'll share that on the takeaways too. The Court of Appeals noted that the statute for the guardianship to do a termination of parental rights, because he did not fail to comply with the zero support order, he complied with it 100%. There was not jurisdiction for the case and his rights could not be terminated. And then in a footnote, the Court of Appeals cited this recent amendment to the adoption provision, step-parent adoption provision. The legislature did not add this language to the juvenile code. Thus, a $0 child support order like the one entered here remains a child support order and you are foreclosed. So another problem that needs to be fixed, but that's another day for another group, I guess. So let's turn, if nobody has questions about substantial and regular support, I think we should turn for a few minutes to the substantially and regularly failing to contact, communicate, or visit with your child. Here, I'm going to pull it up again. So glad I did this. Okay, here we go. The other parent having the ability to visit, contact, or communicate with the child has regularly and substantially failed or neglected to do so for a period of 2 years or more. So I don't know if you've had any cases that have turned on this provision, Trish?
I have not, but I do, want to note that, in Ray Mason, which was decided by the Michigan Supreme Court, 486 Mich 142, that incarceration alone does not constitute grounds for termination. So it's interesting. And then the other case that I noted in my brief, looking back, is that the court in Ray Martin indicated that there was they expressed some doubt that the phrase can be reduced to a specific number of visits within 2 years. So again, I think it's a very, fact intensive inquiry. And I would say that a trial court judge has a lot of latitude in deciding what constitutes regularly and substantial failure to visit, contact, or communicate with the child.
So, let's talk about the example of the incarcerated parent. I mean, even if they're they may not actually physically see their child because it may be difficult or impossible. They have no control over whether the child comes to visit them in prison, obviously. And then obviously in the past year, that was also further made impossible by the fact that we're under the COVID-19 shutdown. But, there's things that a parent could do to comply with this part, that, to communicate with their child, which would then show that they've complied with this part of the provision, even if they aren't able to physically see their child. Trish, do you have any thoughts?
No, I agree. That most certainly there's the statute on its face indicates communicates, so it's not just limited to physical contact. And I also would like to tell you that, the Supreme Court, or let me see if it was a Court of Appeals. Can't remember. In Ray Martin, just mere phone calls and voicemails were sufficient to not trigger a failure to substantially.
So tell me about, do you remember about the Martin case? Because I don't think I'm familiar with that one. Do you remember what happened in that case?
No.
Okay, that's fine. But that's a good one because, so there was voice messages you said, and do you say emails or letters?
Let me see. I'm looking.
While you're doing that, I think in my experience, a lot of the cases turn on what is substantial regular support. I don't see as many cases turning on the whole communicate, visit, contact provision.
No. You know what? I was arguing in my brief. I just want to correct my statement. In Ray Martin, the court indicated that while incarceration alone wasn't enough to trigger a failure to communicate or comply, that in Ray Martin, they said that 2 visits and 1 phone call in 2 years is a substantial failure to visit, contact, or communicate. So I guess at least in that case, there is a bright line rule that 2 years with only 2 visits and 1 phone call was a substantial failure to visit. Yeah.
I had a case, I think it was another one of those guardianship cases that led to an adoption where there was maybe 10 times of communication over the course of 2 years. But if you think about it, if you're a non-custodial parent, like the quote unquote standard, right? The standard parenting time, which it's a whole nother conversation about whether that's an appropriate thing to do. But in 2 years, you only see or talk to your child 10 times. If you're a non-custodial parent, you would normally have every other weekend. And maybe if you're in the same state or close to each other, you could have a midweek visit. So that would be at least 2 times a month. So 2 times a month times 12 is 24. Over 2 years is at a minimum, you'd have 48 times of seeing your child or communicating with your child over the course of 2 years. So 10 doesn't sound like, when you put it in, let's look from the child's perspective. Is that enough to have a relationship with a parent, when there's somebody else who's able to raise them? I'm getting some more comments from our audience about the guardian termination in a guardian case. Oh yeah, this is a good one, Evelyn. Thank you. Where the father's divorce judgment specified that he was only going to get supervised visits, but he never set them up. And that wasn't, and there was, how many times did he try to see his son outside of the supervised visits that were obviously not allowed? He wasn't allowed to do that, but he did. Do you remember how many times he did that in the Milner case, Evelyn? While she's looking that up, that's interesting. Less than 10 times. Okay. And I'm making note of all these cases because they're all really interesting. And then we have another comment about an Ottawa County case that one birthday card in 2 years was,
Wow.
it was enough to meet the standard. Yeah, it was enough. So, oh, and no, he refused to terminate.
Wow. That's surprising.
A judge in Ottawa County, one birthday card in 2 years. I don't know. I would have appealed that. Like, I don't even know how you could possibly say that that is substantial and regular support. He substantially, let me look at the statute again. This darn statute. Okay. Having the ability to visit, contact, or communicate has regularly and substantially failed to do so for a period of 2 years. I don't even know how you don't satisfy that with one card in a 2-year period. But
That's surprising.
I think it is. I think that would be, I mean, honestly, if that's all there was, that would be a case where I could see, even though factual challenges are difficult, it's more of a legal challenge applied to the facts. I mean, it sounds to be like it's a clearly erroneous fact finding or something. I mean, it's like, it's legally not, it's legally not sufficient. Yeah, an abuse of discretion. It's legally not sufficient. Thank you for sharing that. And I guess that's the thing, when you go in front of trial judges, it is just like in custody cases, you don't know what they're going to do. And
No.
it's very often very unpredictable. And your clients, futures are in the hands of judges who you just don't know until it happens. So, I mean, was it worth it going for a step parent adoption under that scenario? Absolutely. 100 every day of the week, I would have said, yes, you have enough to do a step parent adoption. If that was the thing that was the hookup in that case, that was the preventing factor. I never would have thought that one card in 2 years could ever be considered sufficient to overcome that provision. But that probably wasn't appealed. And that happens a lot too, that people are so worn out by the time they go through whatever trial court proceeding they have to go to, and they just don't have the wherewithal, either emotionally or financially or any of it, to appeal. And then, oh, Josh, thank you, Josh. Here's another, this is like the examples are all over the board. But again, it really matters what's in the opinions, because we can use in the Court of Appeals opinions, because we can use those in our briefs, like when you go to the trial court. But Josh Peace pointed out an example where there was a weekly video calls, but that was a substantial failure to communicate. And so I would have thought a weekly video call, I mean, if that's what you have, like that happens when parents are out of state, or if they have supervised visits, or, or for whatever reason, they aren't living close to the child. I would have thought a weekly video call would have been sufficient. I mean, unless it was a 2-second call, I don't know, like, or was it a weekly video call with a newborn, which what good is a newborn? A newborn's not really going to be able to appreciate that. Okay, Josh, now tell us how old the child was. If the child has, this is Evelyn again, if the child has an LGAL through any other type of proceeding, the LGAL is a great source for what the judge is likely to do. Yes, that's a good point. 5 years old, Josh said. So weekly video calls with a 5-year-old. So the 2 years prior, he was like between ages 3 and 5. I would have definitely thought that would have been enough to not terminate.
Absolutely.
Okay, so that Evelyn brings up a really interesting point, because there's not a provision in the adoption code about getting an LGAL. There's a reference to it in a very narrow context that comes out of the Section 45 challenges, I think. And it talks about how to, I think, keep the LGAL, but it's not part of the section 39 that we've mentioned. It's not part of the step-parent adoption provision. I think some judges would appoint an LGAL. You have to ask. I mean, whether there's authority for it or not, like, it's probably better for the child to have one in most cases to advocate for them when a parent's trying to terminate rights. But I don't think it's clear. Like, it definitely could open up the door to an appeal if one wasn't supposed to be appointed, an appeal on that issue. Okay, I have another question here. If you've been able to satisfy termination under A and B, is it still discretionary? The statute does not appear to require a stated basis for non-determination. I hope it's okay that I'm reading this. I had this experience with disastrous effect with a judge who wanted to give the mother a second chance. Okay, so she was the one that was going to be terminated so that the father could have a step-parent adoption with his mother. Wanted to give the judge a second chance to be a better mother. Her second chance has done significant harm. Oh, that's really sad. And any experience on the may terminate. Let's look at it. Okay, thank you for the question. We're going to pull up the statute again. I knew there'd be a lot of people asking questions today. I just had a feeling about this statute. Let's go back up to 1, because I'm not 100% clear if sub 1 applies to all step-parent adoptions. And let's go to the may. I'm trying to find the may language. It must be under here. May issue an order. Yeah, I think it probably would, based on that language, would be one interpreted to be discretionary. But I mean, I think there's an argument. It doesn't say shall, right?
Lisa, I did brief that issue, and it certainly is. It's permissive rather than mandatory, and that's in Ray Newton 238 Mishat 46. So it is permissive, and as you know, the language itself is permissive. Also, I think that's why, even under step-parent adoption, the court still has to make a determination that the adoption is still in the child's best interest. So that therefore is permissive as well. Right.
That's an excellent point, and I think this was really good that this question prompted this, because I did want to talk about this for a minute. So in this section 51, the only time best interest is mentioned. Here we go again. The only time best interest is mentioned in this whole one section of the adoption code is up under 1. And remember, the step parent provision starts down at 5 and 6. So I'm sorry, everybody's getting dizzy. I apologize about that. You still have to consider the best interest of the adoptee will be served by the adoption. See, I'm not sure this specific provision applies to step-parent adoptions, but I don't think it matters, because there's something that is bigger that it does apply to step-parent adoptions. Because the adoption code, unlike a lot of statutes, has a very specific purpose section. So under MCL 710.21a, and if anybody's doing an adoption case, I would suggest you start by reading that section of the adoption code. It talks about what the purpose of the adoption code is, and it's all about the permanency and stability of the child and the best interest of the child. And so my argument has been that regardless of what section of the adoption code you're looking at, and so just so you know, I teach the MJI, the new judges school. I teach the adoption section of it. And so what I tell the judges is that any part of the adoption code that you're working under, the best interest of the child and their need for stability and permanency imbues everything you do. Even if it doesn't appear in that little section, it's still, you have to consider the best interest. And in fact, the adoption code has its own best interest factors under 710.22. It just defines best interest, and then it has I think 9 factors. So they're slightly different than the Child Custody Act, but it's a whole different statutory scheme. So it is discretionary, I think, because the legislature chose to use the word may. Hopefully, in the example that Blair shared, hopefully when the judge denied it, and it sounds like, to give the mom a second chance. Well, I don't know. That's really not what step-parent adoptions are about. That would be more for a juvenile code case, but whatever. But giving the mom a second chance, I hope the judge did so only after going through the best interest analysis under the adoption code. And if the judge made that decision without going through the best interest, that would be, I think, very troubling to me. Evelyn says you need a scorecard to go through the adoption code with all its references back to the other statutory sections, and you end up annotating each section. Yes, yes, all the time. Annotate each section of the statute. Yes, done. And she did not. See, I would have appealed that, but it says
Absolutely.
it's discretionary. But how do you decide whether it's a good idea without going through? Now I have to pull up the other part of the statute. I'm going to do it right now. We're almost out of time, but I think this is really important. And Trish, feel free to pipe in with whatever you want to say.
Perhaps answer Jackie Garris's question, and her question
Oh,
is,
I didn't see that. Go
Okay.
good. Thank you. Thank you.
Okay. What I hear you saying is that if there is no prior court order for custody, then to fight a step-parent adoption, we should file a motion to dismiss per MCL 710.51 subsection 6. Is that correct? And my answer
I would
is
agree.
yes. A
Right.
motion to
Yeah.
dismiss
Yeah.
absolutely would be the appropriate action in that case.
Jacqueline, it says it, Jack, it says having custody, a parent having custody according to court order. So the according to court order is what requires you to have an order, and then the AGD case interpreted that to mean you have to have a court order. So so we're going to go quickly to the best interest factors under the adoption code, which I pulled up on Lexis. Is that it? Here we go. So here's the definition of best interest of the adoptee, and then the code provides 11 factors. And some of them are very similar, but it's like it's obviously some of it's key to 39 cases, but it also has it for other types of cases. Obviously, love and affection, other emotional ties existing between the adopting individual and the adoptee. So now this is about the relationship between the step parent and the adoptee. And then they talk about what to do if it's a Section 39 case, which we're not talking about really today. Here's a look at number 4, the length of time the adoptee has lived in a stable, satisfactory environment and the desirable of maintaining continuity, which I would think probably would very often favor the step parent, unless there's some problems in the step parent's home, right? If there's like abuse or other issues going on in the home, I don't know. The moral fitness of the adopting individual. Wow, so this is really looking at the adopter, not the person they're trying to terminate. Whereas the Section 39 portion of each of these is really looking at not the adopters at all, but looking at the person they're trying to terminate. So it's really interesting how it's handled differently in the putative father context versus the legal father who hasn't had substantial and regular support or contact with the child. So reasonable preference of the adoptee, but only if the adoptee is 14 years or less. If the adoptee, if the adoptee is less than 14, then if the court considers the adoptee be a sufficient age. I've never worked on an adoption case where the child was that old. I don't know about you, Trish. I don't know how old the kids were in AJR, but my kids, I mean, I think one time I had a 5-year-old, and that was like really unusual. Usually in the adoption cases I've worked on, the kids are like less than 3. They were newborns when they went home with the adoptive parents. Or in the case of AGD, I think the little girl was like 5 years old. So, all right. Any other questions? I think we've covered everything I thought was important, that Trish thought was important. Do you have anything you want to add? Any final thoughts?
No, I just was going to state, I guess, when we were talking about the substantial failure to visit, if the father or mother is being blocked, is preventing the opportunity for visitation, that cannot be used as a basis under the statute to terminate. So you can't block the visitation and then try to proceed on a step parent adoption, obviously. That's all. Right.
Well, I think that's a really good point, because what it talks about communication with the child, but I agree with you. That's not is inherently unfair when one parent has control of all the communications, and if that parent is completely blocking. There may be other alternatives. There might be a friend or another family member who can share the communications or correspondence with the child. Has there been a case on that one, Trish, where the parent was?
Well, in Ray ALZ, which was 247 Mishap 264 from 2001, it's very explicit that a parent cannot block visitation and then use that as a basis to demonstrate a failure to comply.
Got it.
So there is that case, yes.
That's fair.
only
That's fair.
one. Yeah.
Good. Well, Trish, thank you so much. This has been super helpful. And again, I think this provision's fairly confusing, even though both Trish and I have worked under it before and worked on cases, and it's just not, it's not the best written provision. And there's a lot of obviously provisions that we have to deal with on a daily basis that are like that. But we're so happy that all of you could be here with us today, and look for the takeaways to come out next week. And then remember, we're going on a summer break. So I'm not doing any webinars again to the fall. I think I might change the format a little bit for the fall, and I'll probably send out a like a Survey Monkey or something to kind of get feedback from the people who have regularly attended the webinars to see what their preferences are, because I'm happy to do anything. But I'm just want to get some feedback on that. So again, thank you everybody for attending, and you guys have a great afternoon. Oh, there was one last question. Oh, no, it wasn't a question. Thank you, Jackie. All right, I'm going to stop the recording.
Okay,
go.
thank you. Thanks, Lisa.
What?